Romesh Thappar versus State of Madras is the first landmark judgment of the Supreme Court delivered on 26th of May 1950. Romesh Thappar was an editor, printer and publisher of a weekly newspaper called Crossroads. The weekly newspaper was sympathetical to the communist cause and was strongly critical of the existing government. On 11th February 1950, over 200 communist prisoners in the Madras province went on strike in Salem Central Jail as they were detained under the Draconian Public Safety Act. The prisoners refused to comply with the instructions of the jailer, which led to an altercation wherein several policemen and jailers were injured. The enraged policeman retaliated by locking these 200 prisoners in a hall and opened fire at them, killing 22 people and injuring more than 100 other detainees. So in February 1950, the weekly newspaper Crossroads criticized the action of the government and of the police in a series of articles which were published and circulated in the province of Madras. So the government of Madras, in exercise of their powers under Section 9 of the Madras Maintenance of Public Order Act 1949, issued an order on 1st March 1950 whereby they imposed a ban upon the entry and circulation of the weekly newspaper in the state of Madras. The order was published in the Gazette and the notification read as follows. In exercise of the powers conferred by Section 9(1)(a) Madras Maintenance of Public Order Act 1949, His Excellency the Governor of Madras, being satisfied that for the purpose of securing the public safety and the maintenance of public order, it is necessary so to do, hereby prohibits with effect on and from the date of publication of this order in the Fort St. George Gazette the entry into or the circulation, sale or distribution in the state of Madras or any part thereof of the newspaper entitled Crossroads, an English weekly published at Bombay. So the editor Romesh Thappar challenged the decision of the Madras government before the Supreme Court of India on the ground that the said order contravenes his fundamental right to freedom of speech and expression conferred on him under Article 19(1)(a) of the newly enacted Constitution, which had came into effect from 26th of January 1950. It also challenged the validity of Section 9 of the impugned Act as being void under Article 13(1) of the Constitution by reason of its being inconsistent with his fundamental right in another reported judgment of Brij Bhushan versus State of Punjab, which was decided along with Romesh Thappar versus State of Madras. The petitioner was the editor of the weekly magazine Organizer, which was part of the Rashtriya Swayamsevak Sangh, and was publishing certain articles criticizing the government of that day. In February 1950, there were widespread communal riots in Dhaka and elsewhere in East Pakistan, which led to thousands of Hindu refugees migrating to West Bengal. Organizer newspaper published some articles criticizing the then government and his policies towards the refugees. So the Chief Commissioner Delhi issued a pre-censorship order under Section 7 of the East Punjab Public Safety Act 1949, directing the publisher and editor of Organizer to submit for scrutiny in duplicate before publication till further orders all communal matters and news and views about Pakistan, including photographs and cartoons. So the editor of Organizer, Brij Bhushan, challenged the said decision before the Supreme Court. Both petitions were decided together on 26th May 1950. So the 6-judge bench, by way of a 5:1 majority, delivered the first landmark judgment creating history and upholding the individual freedom and civil liberties. The question of law, which came to be decided by the Supreme Court in both these petitions, was with regards to the interpretation of Article 19(1)(a) and Article 19(2) of the Constitution of India. The question was whether the public safety and public order laws could curtail freedom of speech and expression, as public safety and public order was not provided as an exception under Article 19(2) of the original Constitution. As public safety and public order was not provided as an exception in order to curtail right to freedom of speech and expression under Article 19(2) of the original Constitution. Article 19, Clause 2 of the original Constitution was as under. Nothing in subclause A of Clause 1 shall effect the operation of any existing law in so far as it relates to or prevents the state from making any law relating to libel, slander, defamation, contempt of court, or any matter which offends against decency or morality, or which undermines the security of or tends to overthrow the state. The Supreme Court recognized that freedom of speech and expression includes freedom of propagation of ideas and that freedom is ensured by freedom of circulation. Liberty of circulation is as essential to that freedom as the liberty of publication. Indeed, without circulation, the publication would be of little value. It held that the criticism of the government exciting disaffection or bad feelings towards it cannot be regarded as a justifying ground for restricting the freedom of speech and expression and of the press, unless it is of such a nature that it would undermine the security of the state or would tend to overthrow it. Thus, very narrow and stringent limits have been set to permissible legislative abridgment of the right of free speech and expression, and this was doubtless due to the realization that freedom of speech and expression lay at the foundation of all democratic organizations. The Supreme Court was of the opinion that unless a law restricting freedom of speech and expression is directed solely against the undermining of the security of the state or it tends to overthrow it, as that has been included under Article 19(2), which provides for the exceptions in order to abridge or curtail the right to freedom of speech and expression, the provisions of public safety and public order which are not provided under the exemption of Article 19(2) were void and unconstitutional. And therefore, the Supreme Court declared the said sections of the Public Safety and Public Order Act to be unconstitutional. These were landmark judgments declaring that the opinion of individual citizens and the views of the press could not be restricted by laws on the ground that they were prejudicial to public order, as the word public order was not included under Article 19(2). It was the first major confrontation between the citizens and the states where the Supreme Court came out decisively in favor of individual freedom and civil liberties. The judgments were widely welcomed as laying the foundation of the freedom of press and made it clear that criticism of the government creating disaffection or bad feeling towards it was not to be regarded as a justifying ground for restricting the freedom of the press unless it was of such a nature as it would undermine the security of the state. This was a major victory for the citizens that kept the heavy-handed state in check. However, in order to nullify the effect of this judgment, the first amendment to the Constitution was brought in the year 1951, wherein Article 19(2) came to be expanded and new grounds came to be added which would permit the state to curtail the freedom of speech and expression. The amended Article 19(2) now provides that nothing in subclause A of subclause 1 shall affect the operation of any existing law or prevent the state from making any law insofar as such law imposes reasonable restrictions on the exercise of the right conferred by the said subclause in the interest of the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation or incitement to an offense. The addition of the new provisions in Article 19(2) drastically curtails the freedom of speech and expression as it originally stood. I will be dealing with other landmark judgments of the Supreme Court in other videos.